Good afternoon, everyone. I'm Desiree Bryant, RPA's Director of Meetings. Thank you for joining our webinar, Paid Leave Under the Family's First Coronavirus Relief Act, Key Issues for Nephrology Practices. Before we begin, I would like to thank MMS Solutions, a renal-specific specialty pharmacy that ships dialysis medications and supplies directly to the patient's home, for their support of this webinar. Thank you, MMS Solutions. A few housekeeping notes for you. All lines will be in listen-only mode. There will be a Q&A session at the end of today's webinar. You may submit your questions at any time using the Q&A feature at the top of your screen. You should see a question mark icon. Now, beside that is an emoticon that you can click as well to express how you feel about today's webinar, the information you're hearing. It's a quick way to let us know what you're thinking. So let's practice. Click the emoticon and give me a thumbs up if you see the Q&A box. I want to make sure everyone knows where that is. That is where you want to put your questions. Oh, excellent, excellent. Please do not submit questions in the chat as those might not be captured or answered, so you definitely want to use the Q&A box. The webinar is being recorded and will be made available along with the slides in RPA's COVID-19 Hub on the website. If you haven't had a chance to visit the Hub, I encourage you to do so. There's a lot of great information. Finally, we will have an evaluation at the end of the webinar, so we would appreciate you filling that out for us. Now, I will turn the mic over to Mr. Jim Riley with McGuire Woods, who will moderate today's webinar. Thank you, everyone, for joining us. Mr. Riley?
Thank you, Des. I appreciate it. Good day to all of you in attendance today. It looks like we've got a good number of folks that are with us. My name's Jim Riley, and on behalf of the RPA and McGuire Woods, I'd like to welcome you to this webinar presentation on some of the more significant employment law changes that have been rolled out over the last couple of months by Congress, of which nephrology practices should be aware, particularly as this pandemic rolls into another month. As I mentioned, I'm a partner in the healthcare department of McGuire Woods, counselor to the RPA, and the moderator for today's discussion. McGuire Woods is an international law firm with over 1,000 lawyers across the globe and 26 offices overseas in the U.S. and overseas. Our employment law and healthcare capabilities are among the largest in the United States. With me today are my partners, Brian Barger and Peter Farley, who have been focusing a great deal of their time over the last 2 months on the COVID-19 pandemic and assisting our clients with questions and issues on a variety of topics. The title of the discussion today is the Paid Leave Under the Family's First Coronavirus Response Act, passed by Congress on March 18th. Well, in today's quickly moving environment, it seems like ages ago. Peter and Brian will let you know how this may affect you and will continue to affect you as the pandemic continues. Peter's a partner in our employment and labor law area of the firm with significant experience in employment, benefits, business, and commercial litigation. Peter's practice encompasses a diverse litigation background representing clients in many different matters. Brian Barger is also a partner in our employment and labor law area of the firm. Brian practiced management, labor, and employment law for over 25 years with extensive experience representing public and private employers with local, national, and multinational operations. Peter will start off the presentation today, and then Brian will follow. We'll be taking questions as you submit them during the course of the presentation, but we'll turn to those questions at the end of the presentation, assuming we have time. In the event that we don't have time, we will follow up with Desiree and try to get some answers out to you on the RPA COVID website. So now, Peter, I will turn it over to you. It's all yours.
Thanks very much, Jim, and thank you all for joining us today. We appreciate the opportunity to speak with you about the Families First Act. Brian and I, as well as other colleagues of ours here at McGuire Woods, have had to address a number of issues for clients that I'm sure you all are facing with respect to this law. And as the slide indicates, it certainly feels like Groundhog Day. I think it was a great movie to kind of indicate or underscore, that we're in a time right now where recurring issues seem to be coming up. We hope that this webinar will provide some additional insight and working knowledge to you about the Families First Act and how these leave rules work, and also address your questions that you may have to the best we can, and if not, we'll certainly be willing to get back to you if you want to email us. Our information will be at the end of the slide. So the next slide for today, we'll go over a number of topics. First, we'll do a quick overview of the Families First Act. Then we're going to cover a specific issue that you all may be seeing a lot of and encountering. We've certainly had a lot of clients ask us about what the integrated employer test is, how different entities within one company or umbrella may be aggregated to determine whether you're covered under this act. Then we'll go into two specific areas related to healthcare: the healthcare provider exception and the emergency responder exception. As you may know, these are exceptions that allow the employer not to grant leave to a particular employee or employees if those exceptions apply. We will cover the small business exception, as well as generally the impact of shelter-in-place orders on the Families First Act. I know we are seeing across the country a number of jurisdictions begin to reopen for business, some allowing partial reopening, some allowing elective surgeries to begin, etc. So we wanted to cover a little bit of how the Families First Act integrates with those, as well as some of the things that are changing along those lines. So now let's turn to the beginning of the presentation and what the Families First Act provides. And I'll go through these slides at a fairly high level. We'll cover a few key issues, but this is just a general review of what the statute covers. As you know, there are really two areas or two buckets which Congress provided in the Families First Act. One is emergency paid sick leave, and the second is emergency paid family medical leave. Now, the emergency paid sick leave is a new provision, new statute on its own that gives an employee up to 80 hours or 2 weeks, the equivalent for part-time, of paid sick leave. We'll get into the details in a second, but there's 6 ways an employee can receive paid sick leave under the emergency paid sick leave statute. The second is the emergency paid family medical leave, and as you've probably seen and can tell from the title, it is an amendment to the Family Medical Leave Act, but there are some important distinctions here about how this piece of emergency family medical leave works independent of the Family Medical Leave Act and ways it works together. So we'll talk about that as we get into our presentation. But as you may know, and as you can see on the slide, it's up to 12 weeks of leave. The first 2 weeks are unpaid, and the remaining 10 weeks are paid. Unlike FMLA, all of that's unpaid. The triggering event is only a single item, and that is to care for a child. We'll get into a little bit more of that. It's actually the same as the 5th item for the paid sick leave. And importantly, the emergency family medical leave can run concurrently with emergency paid sick leave. So next, when we look at what does the Families First Act cover in more detail for private employers it only applies if the employer has fewer than 500 employees. Very much somewhat counterintuitive, where usually the statutes, at least at the federal level, start at a lower level of employment like Title VII or FMLA and go up. This statute applies really to smaller employers. It has different pay amounts depending on the triggering event. There can be a full paid leave or a partial paid leave, 2/3 of the amount. We'll get into that in a minute. And importantly, there are caps related to what an employer must provide an employee for purposes of the various leaves that are provided. Depending on the reason for the absence, an employee may also be entitled to family medical leave, regular family medical leave, or unpaid state leaves, state or local leave laws. California and Los Angeles in particular have enacted recent paid sick leave laws to try to grant additional leave to larger employers. We've seen paid sick leave expansions in New York and New Jersey. So really important to pay attention to your local, state, and local paid sick leave laws that may also apply to employees in these areas. In addition, we do want to mention that as you may have paid sick leave policies or PTO or vacation policies that allow employees to take paid time off, these also may be able to be used by your employees depending on the circumstances. So in some respects, this is a little bit of a combination of various leave laws that you want to keep in mind when evaluating the employee's request for leave and what he or she is looking for. So next, let's look at what the paid sick leave qualifying reasons are. As I mentioned a moment ago, there are 6. And as the slide indicates, the first and most important question to ask when evaluating qualifying leave under this statute is that the employee is unable to work or telework due to a need for a leave. Okay, so it isn't that work's not available. There is work available. The office, the business is open or partially open, but this employee is unable to work or telework due to one of these 6 reasons. The first is quarantine, that is, that the employee is subject to a isolation order due to COVID-19. The second one is self-quarantine, that is, that the employee has been advised by a healthcare provider to self-quarantine due to COVID-19 related reasons. The third is symptoms or diagnosis, that is, they are experiencing COVID-19 related symptoms and seeking a medical diagnosis. Now, for that last one, I want to note, and you all may be aware of this, but the CDC recently updated the symptoms for COVID-19, and I just want to pause and note to double check that. They are right now cough or shortness of breath or difficulty breathing, and then, or it could be 2 of the following conditions. So if you have cough or shortness of breath or difficulty breathing, those are symptoms. Or if you have 2 of these, fever, chills, repeated shaking with chills, muscle pain, headache, sore throat, or new loss of taste or smell, those would qualify. Importantly, for that third one, you have to be seeking a medical diagnosis. So you can't just self-diagnose yourself and then say I'm entitled to leave. Wanted to point out that because that's been developing as Brian and I have been working with clients, and we've done a couple of webinars on this subject. That's been an evolving area. Next, the other 3 qualifying reasons: caring for a quarantined or self-quarantined individual. Important for this one is you need to have a relationship with the person that you're caring for. It can't be just someone that you're providing that on a volunteer basis, like a family member or someone you live with, like a apartment mate, what have you, that's where this one will really come in. Child care is the fifth reason. That's caring for a child whose school or place of care is closed for reasons related to COVID-19. Most schools around the country are closed, or many are, but as the school year ends in June, there are going to be different needs that employees may have that to care for a child that could arise. And so this child care provision is going to continue to be applicable, we believe, even as we get into the summer months. As you may remember, the Families First Act sunsets on December 31st, of 2020. So these reasons could continue on even as we get into the summer months. And then the sixth reason is substantially similar condition. That is, someone is experiencing a substantially similar condition as specified by the Secretary of Health and Human Services. That is one that could come up and develop later. But these are the six reasons for the employee sick leave. Now, if we turn next to the emergency family medical leave qualifying reasons, this is, again, as I mentioned, just one reason. It's the child care reason. So it is the same as reason number 5 for the sick leave. But I want to, again, emphasize at the top of our slide, unable to work or telework due to a need for leave. So again, you have to ask if there's work available. Okay, if there's no work available, if we've closed, then that would not trigger this leave and it also wouldn't trigger the sick leave. Important to note, just to keep these two leaves straight, emergency family medical leave does not apply to the medical conditions that the sick leave law applies to. And when this originally came out, it was somewhat counterintuitive, because when we started to think about this statute and the amendment to the Family Medical Leave, one would think that maybe the Family Medical Leave Act would have the medical reasons in it, but it actually doesn't. The sick leave has the medical reasons in it, and the Family Medical Leave has the child care reasons. So just want to reemphasize that for you all. Now we'll shift gears just for a minute to the pay rate and caps that relate to the various leaves. So first, under the quarantine, self-quarantine, and symptoms or diagnosis reasons for sick leave, emergency sick leave, you get full pay. The employee gets his or her full pay up to a cap of $511 per day and $5,110 in the aggregate over the 2-week period. Remember, this is 80 hours, 2 weeks of equivalent leave for these reasons. Then if you are receiving the leave due to the care for a quarantined, self-quarantined individual, or the substantially similar condition to COVID-19, the leave rate is 2/3 of pay, up to $200 per day, and $2,000 in the aggregate, again, over the same 2-week period to 80 hours. If we are looking solely at the child care reason for the leave, then it is similar to the last one, 2/3 of pay, up to $2,000 per day, and $12,000 in the aggregate. Remember, the child care leave under the Emergency Family Medical Leave Act lasts up to 12 weeks, 10 of which are paid, 2 of which are not paid. But as we indicate in the slide, the sick leave for reason number 5, child care, and the emergency family medical leave can be combined. So if an employee is eligible for that leave, it is likely that he or she would ask first to exercise their sick leave rights and have the first 2 weeks paid under the sick leave statute, then transition to leave under the emergency family medical leave statute, and have the next 10 weeks paid if they need it and need that entire period of time. Lastly, as noted on this slide, the FFCRA says that the regular rate of pay is what you use, or the applicable federal minimum wage or state or local minimum wage, whichever is greater. So in most circumstances, we're going to look at probably their regular rate of pay, but as the highest amount. But if they are a minimum wage employee, or they're being paid a state minimum wage that's higher than the federal, that would be your applicable rate. So just keep in mind, it's the greater of their regular rate or the applicable federal minimum wage or state or local minimum wage up to the cap in each type of qualifying leave. Next, we wanted to talk just a moment about how the tax credits work for purposes of these leaves, because a lot of folks have asked and have focused on, rightfully so, the tax credits and how they can be taken. There was a lot of discussion when the statute was passed about how the tax credits would work, and thankfully, I think we can say that the IRS did make this one at least fairly easy in terms of how you can take the tax credits, which is not typical for the IRS, right? So under the FFCRA tax credits provisions, you get a dollar-for-dollar reimbursement for covered employers through tax credits for all of the qualifying wages up to the applicable per diem and aggregate payment caps. You can take it when payroll tax is remitted, so you can deduct it from your payroll tax remittance. And if you have a higher credit than your remittance, you can provide or apply for an expedited advance or credit when it exceeds the amount of the employment taxes that are owed. So one of the examples in the regulations is if all your taxes owed for your employees equal $5,000, and you have a credit up to $8,000 due to the leave taken, you take all $5,000, you'd have $3,000 still left to take, and you can try to get an expedited advance or credit on that balance. The important thing to note is that you combine all of your leave in one. In other words, you don't have to do it you don't have to seek the tax credit employee by employee. If you paid out $5,000 of leave, then you can take that against all your employment taxes. So that's also, I think, a helpful way for folks to be able to do that. Then I want to note, before switching over to Brian next, just the last point on this slide, which is the tax credits extend to amounts paid or incurred to maintain health insurance coverage, because while an employee is on leave, he or she is still entitled to participate in your health plan, and the employer will have the employer share of the healthcare cost, and the employee will have the employee share of the healthcare cost. And Congress decided that was something that could count towards the tax credit. So with that, I'm going to switch over to Brian, and he is going to go through the integrated employer test and a few of those slides. Brian?
Yeah, thank you, Peter. Good afternoon, everybody. Again, thanks for joining. We sure appreciate it. We know it's a terribly busy, crazy busy time of year, especially for physicians like yourselves and your practices. So again, thank you. Separate and apart from the rules about FCRA, when I'm counseling clients about these issues, apart from the mechanics, there are really three big questions you have to answer up front. Question number one, am I covered at all? Am I covered? Am I required to do FCRA, or am I just simply dealing with regular, high-test, straight Family and Medical Leave Act rules, ADA rules, and PTO rules, or do I need to worry about FCRA at all? Question number two, if I'm covered by FCRA, are there exceptions that apply to me in my practice? And frankly, there are a lot, which we'll talk about. And number three, if I'm going to use one of these exceptions, am I going to use them for everybody or only certain individuals? Those are the three questions. Am I covered? Are there exemptions? And how do I want to use those exemptions? On the am I covered issue, I'll mention one trap that comes up quickly. For a lot of people. A lot of individuals think, okay, well, I have to have less than 500 employees to be covered, right? And my practice is fairly small, and we don't have 500 people running around the office, and so I'm definitely covered, right? Well, the answer is it depends. Not necessarily. There is a separate test for whether related legal entities are deemed to be, quote, integrated enough to sort of have the count included together. And so the way it works under FCRA is that separate U.S. subsidiaries are deemed a part of a parent and potentially above the 500 employee cutoff and not covered by FCRA unless you can show that the entities are, quote, not integrated. And so what you're looking at is a test to try and figure out, okay, when I'm looking at separate LLCs or separate legal entities that are affiliated in some way, do we combine all their employees together or can they stay separate? And to do that, there's a four-part test. It's a four-part test that actually comes out under the regular FMLA. And what they ask for is they look for information about the degree of common management, your officers, your directors, your key employees, the interrelationship between operations. Do you share payroll? Do you share sort of employee support? Do you swap employees back and forth across the entities? Do you share, medical record systems? Do you share common accounting, common payroll systems, etc.? They also look at number 3, centralized control of labor relations. Do you share HR personnel? Who actually makes hiring and firing decisions? Are they integrated decisions, or does everybody sort of stand separately? And then they look at the degree of common ownership and financial control. Common ownership, again, for subs, is not too uncommon, but they're also looking at how integrated are your finances, which again varies by practice. It's not a test where any one item will necessarily knock you in or out. It's actually a balancing test, which makes it hard. But there's no doubt that when the DOL and others look at this, they do put more stress on the degree of overall interrelationship and control. Who actually sort of pulls the levers? How integrated are you? Or really how much of a standalone entity do you actually run as in practice? So it's a hard test. But that's the test. One key thing to note, though, and this is very confusing, the government, like anybody else, doesn't make it easy. There's a different test, by the way, for whether you're deemed to be sufficiently integrated under the Payroll Protection Program that was separately adopted by Congress. It's a different test. It actually follows an affiliation rule with a different standard. So you may think to yourself, well, I passed one, that means I passed the other, right? Not necessarily. You may, but you may not. And so you may be asking yourself, so what if we get it wrong? What if I raise my hand for the tax credit? What happens? What do I need to consider? Well, the things that they'll look at is they'll try and look at, for example, for your practices, do you have standalone clinic sites with separate LLCs, but are they really part of a larger group of shared sort of integrated practices? Do you perhaps have separate LLCs or other entities, but they're part of an overall larger healthcare system? Obviously, we see that a lot with physician practices where they're merged into, for example, the Novant system or the Atrium system, or you name it. And the practices are actually part of the larger healthcare system. Sometimes that definitely is an operational thing. Sometimes it's simply branding. It really varies by practice and by region. So we are happy to talk to you if you have questions about it. But they also look at the other kinds of things that we see pop up. Do you have a separate physician practice LLC with a related surgery center? And even though they're sort of separate in theory, again, under the integrated employer test, are they sufficiently integrated? That's going to be the question. But these are the kind of common things that we see. As to the risk, well, the risk is that if you look at this, you think to yourself, I think we're sufficiently not integrated so that we're below the 500 and I get to count myself and my practice freestanding and we're below 500. And let's pretend you apply FCRA to your employees, and when you do so, you ask for and get the related tax credit, which is great. That's one good part about FCRA. If you're going to give the leave, you get money to help pay for it. You get money for the healthcare premiums, as Peter said. That's a great thing. But that money has strings, and you got to remember, if you're ever second-guessed on this and you lose, for example, if the Department of Labor says, I know you raised your hand and said you have less than 500, but we really believe you're integrated and should have been combined with XYZ entities. Therefore, you are in violation of FCRA, and you raised your hand when you shouldn't have. Well, what's the penalty for that? Well, the penalty is the same penalty that exists already under IRS regulations. You basically ask for a credit when you shouldn't have, and there's a penalty for failing to deposit federal employment taxes, because that's what you're doing. You're doing an offset on those taxes. So basically, you have failed to deposit those taxes. And what's the penalty? Well, it's 10% if it's more than 15 days, which in this circumstance would definitely be the case. And so you got to think long and hard about whether you want to raise your hand. And if you have questions about this, Peter and I are spending a lot of time doing these analyses for folks, and we're more than happy to help you. But it's just something to keep in the back of the mind. It's not risk-free. The other thing I would say is talk to your legal counsel. The position that you take about whether a group of entities is or is not a single enterprise has other issues beyond FCRA. So you need to think long and hard about whether you really want to tie yourself legally at the hip with other entities or not. Many times you're tied whether you like it or not, and you are what you are. But sometimes for things that are on the edge, you might want to think carefully beyond FCRA about whether you want to raise your hand or not. That raises the question, okay, so let's pretend I'm covered. I don't think I'm integrated sufficiently to be above 500, or even when I am integrated, it doesn't cross the 500 mark. I'm below 500, so I'm definitely covered by FCRA. And you're thinking to yourself, how am I going to give all of this time off to my employees? I have a practice to run. We're in the middle of triage, day-to-day here. We've got key issues with individuals who have COVID, who some of the symptomology and unfortunately some of the problems that people develop definitely impacts nephrology. So you may be busier than normal. You may be scrambling day to day, and you may not have any flexibility whatsoever to give people leave under FCRA. And you would rather not if you could avoid it. Well, the good news is for healthcare providers, there are two big exceptions. There is a healthcare provider exception, and there is an emergency responder exception. But the thing to keep in mind about this, and we'll talk about it, you must affirmatively opt out, meaning you have to tell your employees, by the way, we are hereby designating ourselves as a healthcare provider or emergency responder, and you, employee X, are particularly a healthcare provider or emergency responder, and therefore for you, we are opting out of FCRA coverage. Now, you don't have to send a notice to the Department of Labor, but you do have to do a notice, at least to your individual employees. And so that's related to that. Just keep in mind, the biggest question we got from a number of individuals is when you're looking at the definition of healthcare provider and emergency responders, is it really limited to physicians and nurses and individuals like EMTs, or is it broader? And thankfully, when the regulations came out, they clarified this issue. And the good news is it is extremely broad definition, extremely broad, and we'll talk about it in just a second. But for healthcare providers, it's anyone employed at certain institutions like doctor's offices, clinics, hospitals, nursing homes, medical schools, and most of their related contractors, and most of their medical services and suppliers. The same thing goes for emergency responders. It's anyone necessary for the provision of transport, care, healthcare, comfort, or nutrition for patients or others needed for the response to COVID-19, plus, here's the kicker, anybody who works for those facilities employing these individuals and whose work is necessary to maintain the operation of the facility. So it's not just doctors, nurses, PAs, clinicians. It's also records personnel, insurance individuals, receptionists, frankly, anybody you need to keep your practice up and going. So again, if you look at the full definition of healthcare provider, you can see this quoted from the regulations. They cite doctors' offices, hospitals, healthcare centers, clinics, post-secondary educational institutions like UVA and Duke that have medical instruction, medical schools, health departments and agencies, nursing facilities, retirement facilities, you name it. It also includes pharmacies and labs. Also, the regulations noted, I think importantly, that this includes both permanent and temporary facilities. So if you've set up temporary off-site facilities to help deal with COVID, this sweeps it in as well, not just your regular standalone site. And again, like I mentioned also, it's broader than just your entity. It also applies to the extent you had sub-entities in organizations that do contract and service providing and support to you to sort of keep your operations running that may or may not be directly related to you, but it also includes entities that actually make the medical products themselves or are involved in medical testing equipment, et cetera. So as you can see, it's extremely broad definition by design. The same thing goes with emergency responders. Again, it's a very broad definition. They list out, as you can see in the example, military and National Guard, law enforcement, correctional personnel, firefighters, EMTs, which may apply to you, physicians, nurses, public health personnel, 911 individuals, et cetera, et cetera. Again, ridiculously broad. But there's a trick to this. And the trick, I will say, is twofold. Number one, you have to give an individual notice to folks that they're actually covered, and so or not covered. So if you're going to exempt somebody out, you can do it for all of your personnel, and frankly, I don't think you're going to get second-guessed on that a lot based on the broadness of the definition for most of your practices. But you have a choice. You don't have to exempt everybody. You can opt out for certain individuals and not others. So, for example, you can say, okay, for all of our physicians, all of our nurses, all of our PAs, all of our other clinical practitioners, our lab personnel, our key medical records personnel, our other direct support patient-facing personnel, we are opting out for all of you. But for the XYZ other back office people, some accounting individuals, some individuals who also sort of do sort of organizational or marketing for you, or other personnel, you can say you are not necessary. And for those individuals, we are not going to opt out for you, and you remain covered. So you can pick some or all of most of your personnel to sort of be in or out, but you've got to be clear about who's in and who's out. The other thing I will note is, and Peter mentioned this earlier, even if you opt out, and this is, again, an employee to opt out, not an entity opt out. Even if you opt out for certain employees, it's not like the rest of PTO or law goes away. Even though you exempt individuals out, the law is clear and the regulations state the exception does not impact earned, accrued vacation, sick leave, PTO, et cetera. So that does not go away. Likewise, the exception does not prevent individuals from taking that. And you may ask yourself, well, I'm not too keen on that either. I want to suspend my PTO, or I want to put other restrictions on how and when people could use vacation. And you can do that in some circumstances. Just keep in mind, that's a separate issue from FCRA. And I will tell you, Peter and I have been spending a lot of time on this issue for a wide variety of employers. And it's complex because every state has different rules about that. It depends on your individual policy regarding PTO and sick leave, but also state wage and hour law restricts how and when you can put limits on the use of PTO once it's accrued. And so to the extent you have questions about that, just keep in the back of your mind, just because you raise your hand and exempt yourself out of FCRA doesn't mean the rest of this law somehow goes away. It's still there in the background. But otherwise, these exceptions can be a use to you, and you really ought to think through it. So with that, I'm going to turn it back over to Peter and let him chat a little bit about the small business exception.
Thanks very much, Brian. So, as I mentioned at the outset, the statute, unlike a lot of other federal statutes in the employment context at least, has a maximum number of employees it applies to. It goes up to 500. If you're over 500, as Brian has just been talking about, you don't have to provide paid leave under the Families First Act. But there is, as the slide indicates, a small business exception. But it is a tricky exception and could present some challenges for small employers to meet. So the first test is you have to be fewer than 50 employees. And I would say the same analysis goes here as it would in determining whether you are subject to the 500 employee cap or not. You have to look at your employees, both under your just a standard analysis and the integrated employer analysis as well. So then, next, you have to ask yourself if providing either the sick leave or the emergency family medical leave would jeopardize the viability of the business as a going concern. That's a big standard. That's a tough standard. And I'll get to it in the next slide, but that is where Congress decided to draw the line for these small businesses. Again, a little bit different than what we normally see, but the clear intent based on this standard is the law is intended to provide leave in most circumstances, even for small employers. And you'll see as I get to it in a minute, the viability of a business as a going concern is a tough standard. This can be applied to particular employees or the entire entity, provided the test is met. That is the saving grace here, that if you have a key employee who you do not think you can survive without if they go on leave, then provided you can meet the test, then you can use that exception. So when we look next at what these specific rules are with respect to the small business employer exemption, there's essentially three. And note in the middle of the slide the bolded all caps or. This is not a conjunctive test, but a disjunctive test. So first, would the leave result in the small business's expenses and financial obligations exceeding the available business revenues and cause the small business to cease operating at a minimal capacity? To me, that's a stringent test. That's a kind of your business is really going to essentially be unable to operate even at a minimal capacity. The next one is the employee or employee's absence would entail a substantial risk to the health or operational capabilities or specialized skills, knowledge of the business or responsibilities. This is one that I could see very much could apply to some of your small practices, because if you had a certain key employee whose absence would result in one of these material impacts to your operations, to your practice, to your business, how you function, how you serve patients, etc., that would be one area to potentially consider. Very factually specific, as I think you can tell. The third one is we don't have enough people who are able, willing, and qualified and or available at the time and place needed to perform the labor or services provided by the employee requesting the leave, and these services are needed to operate at a minimal capacity, kind of like an MVP status for that particular employee. We need this person. We don't have other people to replace him or her, and we can't do what we need to do to operate at a minimal capacity. The key takeaway from these three elements, really, as you can tell, is they are very factually specific. We have not seen a lot of development on the regulations with respect to this. The slide indicates the regulatory site for this, Section 826.40B, and there's a regulation related to it that covers this detail. But there's not any further guidance yet on how facts might fall into these particular scenarios. So it would be best to get advice on it. We'd love to help if we can on your specific questions, but to get advice as you face potentially these issues to determine whether this exception and this exemption will apply. Noted on the next slide for the small business employer exemption, this is for child care reasons. That's the sick leave number 5, or the emergency family medical leave reasons. The facts and circumstances must be documented in order to be able to establish this small business employer exemption. You don't need to send anything into the government, but there is a record retention requirement that you maintain it for 4 years. So to the extent that there would be an audit by the Department of Labor or a complaint by an employee about whether or not you truly did fall into this exemption, then you want to make sure you've maintained those records for 4 years in order to be able to respond to a inquiry along those lines. The next slide shifts gears a little bit to the issue that I spoke about at the outset as an important gating issue for determining whether someone is entitled to the leave, the unable to work or telework. And we have, Brian and I and our colleagues have spent a lot of time with respect to this particular issue with clients because it also presents a very factually specific issue. So first, note the emphasis on the word personally. It is employee specific, that particular employee cannot work or telework due to a need for leave. So it is going to depend on what work is available for the person, what the circumstances are for them to be able to perform that work, and whether or not they can do so either at their regular place of work or at a place where they can telework. It can, in some circumstances, include orders that advise all citizens to stay in place. But it's still, as we noted at the bottom of the slide, you still need to be able to show that the employer has work and the employee is personally restricted. Okay, so it's not applicable where the employer does not have work for the employee. One of the notes that one of the provisions of the regulations that I'll note before turning this back over to Brian is when they talked about unable to work or telework, if an employee is at home and has COVID symptoms and is dealing with those symptoms and can't telework, that could lead to a reason for the leave, likely would. But if you are at home and you have to really dive into the person's inability to telework, and it's okay to ask for that if they claim they can't telework, to document those reasons, it really will be fairly exceptional, at least based on what the regulations and the preamble to the regulations indicate. I know I've said it a couple of times, it will really depend on the individual circumstances, but the key really to ask yourself is, do I have work for this person? Yes or no? If you do, and they can't do it at their normal place and they can't do it somehow by teleworking, then they're going to be eligible for the leave. And with that, I'll shift it back over to Brian to finish us up related to shelter-in-place orders.
Yeah, thank you, Peter. So, we're going to wrap up talking about the number one question we get from clients about FCRA, and then we'll take some of your individual questions as time allows. So here's the number one question we get. So if you think about, oops, I just advanced too quickly. If you think about the FCRA reasons, 1 through 6, the number one qualifying reason at the beginning for emergency paid sick leave is if you're subject to a quarantine order, right? And so when the act first came out, the big question is, well, what about shelter in place? I'm not being individually quarantined per se. I haven't been told to stay home because I have COVID or because I've had direct exposure. I haven't been personally told by my local health department that I need to stay home. But yet, I've been told generally by the locality or the state that I need to shelter in place. And my company's not essential, or I'm not essential, and therefore don't I qualify for FCRA reason number one? And the short answer, as Peter said earlier, is it depends. It depends on whether work is available for you. If the reason for the shutdown, though, the reason that you're at home is not because there is work otherwise available at the company, but the organization, your practice, has simply had to furlough individuals because you've lost work. And even if that lost work is due to the shelter in place, that does not qualify for FCRA. That's because the reason someone's out is because of the lack of general work. They may be eligible for other things, unemployment, et cetera, but they're not eligible for FCRA. So here's an example straight out of the regulations. In the preamble, they said a cashier previously employed at the coffee shop who was subject to a stay-at-home order would not be able to work even if he were not required to stay at home. As such, he may not take paid sick leave because his inability to work is not due to his personal need to comply with the stay-at-home order, but rather due to the closure of the place of employment. Or put another way, closures because of a shelter-in-place or stay-at-home order where a business is basically not essential or a person's role is not essential do not trigger FCRA. So you got to think about why is someone actually at home. And simply because the shelter-in-place order applies does not mean that FCRA qualifying reason number one kicks in. The same thing goes with furloughs, and we got this question a whole lot. So if I've just furloughed people, or I've been forced to reduce their hours because my practice is off because of elective surgeries are off and people are not coming in as much unless it's an emergency situation. Therefore, we've had to furlough some folks or cut their time. Does that qualify under FCRA? And the short answer, again, is no. The reason they're out is not because of a FCRA qualifying reason. The reason they're out is because of your lack of work, even if it's indirectly related to the shelter-in-place order. So here's an example straight from the regs, from the preamble. If my employer is open but furloughs me on or after April 1, 2020, can I receive paid sick leave or expanded family and medical leave? This is from the FAQs. And the answer is no. If your employer furloughs you because it does not have enough work or business for you, you are not entitled to then take emergency paid sick leave or emergency family medical leave. The same thing applies if you totally close your work site, if you subject employees to reductions of force, or you reduce hours. Again, the reason has to be that it's a quicker FCRA trigger that personally prevents the employee from working or from working a full schedule. It has to be that trigger, not these other sort of indirect parts. And that can be complex. I'll admit it's a complex thing. It's also complex because people sort of confuse those orders with sort of self-quarantining and other things. And so to the extent you have questions about that, certainly, or particular issues with your individual employees, in addition to your own counsel that you may or may not have, certainly Peter or I are more than happy to help. So with that, let me pose a couple questions that we see coming in over the chat line. Speaking of questions, before I get to that, if you have questions later about this, certainly we have contact information for Peter and myself. Beyond ourselves, frankly, we have a huge COVID response team, both by industry and by practice area, which includes, our broad healthcare practice. Peter, Jim, and myself are all on that COVID response team, but if you want the full list of individuals, you have information there. Likewise, we have a huge panoply of resources available on COVID-19 on all sorts of different topics across industries, across practices. I think the last count I saw since this fun COVID-19 crisis sort of hit, I think our firm has put out over 160 different articles. We won't bore you with all those, but if you would like to see them sorted by topic, etc., go to that site. It's free. and you're happy to use them. So with that, let me start with a question. Peter, here's one question. It says, when staff take time off to care for a sick child, not related to COVID, do we need to pay for this as sick leave? And so I'll take that one. The short answer is, yeah. I mean, that's not a FCRA issue at all. It's not, if it's not related to if it's not related to FCRA, then you're looking at a straight up analysis about whether someone's covered by regular family and medical leave, which would be unpaid, whether people are covered by any kind of paid sick leave law under state law, or whether you're covered by your own personal practices, PTO, sick leave, or vacation policy. And so whether or not you have to pay them is governed by those separate things. It would not be a FCRA issue. And that's important to remember. I think we all get so consumed with the rules about these new laws that we forget that the rest of the rules haven't somehow evaporated. And that's a great question. Here's another question I'll throw out to you, Peter, if you want. It says, we are paying an employee their full wage while out on FMLA. And so they're paying the total amount. Is the tax credit the full wage or the 2/3 that you mentioned? And so I think what they're mentioning here, they said the word FMLA, but I think they meant EFMLA. So they're paying somebody the full wage while they're out. They're basically grossing them beyond the 2/3. Can you get a credit for that full amount, or do you only get a credit for the 2/3?
Yeah, great question, and the answer is the 2/3. The tax credit is limited to the cap of the type of leave that the person is taking, and the applicable cap that goes along with that. So as we discussed earlier, if it's one of those reasons where you get one of those areas where you get $500+ per day, you would get that level tax credit. But if you paid more than that, the tax credit's going to be limited to the amount of the cap for that particular leave. So in that example, Brian, I think the answer is yes. It would be limited to, even though you're paying full wages or full pay for that person who's on EFMLA, the tax credit's going to be capped at the 2/3 of the amount up to the max for EFMLA leave.
Okay. Thank you, Peter. I think we have time for one more question, and we'll turn it back over to Desiree and Jim to wrap us up. Last question. We are paying an employee wages under FCRA. What specific steps do we need to take to apply for the tax credits? And it's interesting, if you think about it, as Peter mentioned earlier, it's fairly simple. We were really worried initially when the Act came out, before the regs came out, that there would be some sort of process where you had to sort of raise your hand and submit a form and sort of go ahead and pay your taxes and wait for some sort of remittance to come back to you, and there would be some sort of lag in the credit. But that's really not the case. It's a direct offset against your regular payroll taxes, and so you actually sort of do it on the front end as part of your normal remittance. And in fact, as Peter mentioned earlier, in some cases, if your costs for FCRA exceed what your remittances normally would be, you could ask for an accelerated payment from IRS. There's actually a form for that in the IRS that you can submit for that accelerated grant, but otherwise it's just an offset. And there's nothing to necessarily fill out. You have to document while you're doing it in case you're audited later. But thankfully, I will say, separate from the DOL FAQs that you can Google and find out there on FCRA, if you Google sort of IRS FCRA tax credits, you will pop up a really good guidance that IRS has out there at FAQs about how the tax credits work, how to account for the remittances, and how to sort of do that sort of on an operational basis. And I will say both the DOL and IRS have done a pretty good job, I think, trying to get ahead of this and give a lot of detail to individuals about sort of how this applies. So if you review that information and still have questions about that, certainly reach out to Peter, reach out to me, and we're more than happy to help you. And with that, I think we're done with our time, and we'll turn it back over to Jim and Desiree.
Yeah, thank you very much, everyone.
Thank you, Brian, and thank you, Peter. That was an excellent discussion of FICRA and the related issues. We really appreciate it. To all who have attended, we want to thank you very much for being with us today. As Brian and Peter mentioned, if you have additional questions, please feel free to reach out to them directly or me. And we will take the questions that we have not been able to get to and try to answer those as well and get them to Desiree so she can put them up on the COVID portal that the RPA has. So again, thank you very much. And Des, I'll turn it back to you.
Thank you very much. Again, I'd like to thank everyone for joining us today. The replay will be in the replay and the Q&A summary will be in the COVID-19 Hub on the RPA website next week. So you can go there to relook at anything if you missed something or just need to hear something again. And again, I'd like to thank MMS Solutions for their support of our webinar today. So everyone be safe, stay well, and have a great weekend. Thank you very much for joining us.
Thanks, everybody.